back, everybody, for our afternoon programming. So this morning, we talked a little bit about things to consider and kind of that initial launch phase. This afternoon, we will continue talking a little bit more about the mechanics and the essentials of running your law practice. And then in this next session, and then after that, we will talk about some of the ethical considerations that we have to keep in mind, and some unique ethical considerations for solo practitioners. And then we will end our day together with some guidance on how to create a joyful and sustainable law practice. It's not just about the work, and we need to be there for ourselves and for our clients, and so we get some ideas about that. But to start off, for now, yes, it is off.
There's a switch right on the body. There you go.
Thank you.
I'm not going to repeat all that. Okay, so I'm just going to, as I did earlier, very, very briefly introduce the panelists. Their bios are in the materials we distributed earlier. Next to me is Carrie Kennedy, and Carrie is a graduate of GGU. She's been in solo practice in employment and business law in Redwood City since July 1992. She is a member of the Employment and Business Law sections of the San Mateo County Bar Association and is chair of the Client Relations Committee, which oversees the mandatory fee arbitration program. Next to Carrie is Jerome Fishkin. He began his practice in 1971 and has appeared in nearly every courthouse in the greater San Francisco Bay Area. He has represented clients in civil, juvenile, and criminal and administrative hearings. In 1978, he became employed as a research attorney with the State Bar of California and became a prosecutor of disciplinary cases in 1983. As a senior prosecutor, he then left the bar to open up his own practice, focusing on the area of attorney ethics. And then next to Jerry is Lindsay Slater. And Lindsay began practicing law in 1976 as a plaintiff's attorney in Los Angeles. In 1980, she began practicing adoption law. And since 1992, she too has practiced in the area of attorney professional responsibility and attorney discipline. Today, she is a partner in the Walnut Creek law firm, Fishkin and Slater LLP, and focuses on advising and representing other attorneys. She also advises law students in the moral character and fitness process matters. So really excited to have these three experts with us today. And we'll be talking initially about some of the sort of financial issues and some of the relationships between attorneys and clients. And so we're going to start at the beginning of that relationship, a retainer agreement or some kind of agreement between you and your client that says you are the attorney for this client. So I want to get a sense of what are the elements that should be in a retainer agreement, what are things that are not necessary or might actually get you into trouble to have in that, and I don't know if Lindsay, if you want to get us started with...
I will get started, and I will share that with the panel as well.
Oh, and actually, I'm sorry, Lindsay, before I don't want to interrupt, but I want to make sure the folks know we have a lot of handouts that the speakers provided, and we'll be referring to those throughout this session and the next session. So feel free to grab, there I think are 4 or 5 handouts. So we're not going to follow them closely, but they're great resource materials and great reference materials, and we'll be speaking about them throughout.
Thank you. The attorney-client fee agreement. You won't be disciplined by the state bar if you don't have one, but you'll get in a lot of trouble because you won't be able to establish the basics of your relationship. We call it an attorney-client fee agreement rather than a retainer agreement. And the fee is the issue that you must address and be very clear about. You are required to have written fee agreements under Business and Professions Code 6146 through 6149. There are different sections for different types of fee agreements. For contingency, plaintiff's contingency cases, and for medical malpractice cases, there are two separate kinds of agreements that are governed under the B&P code. You also have an hourly fee agreement that is defined by statute in the B&P code. And if you will look at those sections, it tells you the items that you're required to have in the fee agreement. Very important that you do that and update it every year. There is, for example, the requirements often change. And say you were to use, you got a sample fee agreement from another attorney who's been practicing in the field that you're in, and you attempt to use that for the basis of your own fee agreement, then you may find that some of the laws have changed. For example, we've had several different changes over the last 35 years over whether or not you're required to have malpractice insurance and whether or not you're required to state that in your fee agreement. So, you have to look at the B&P code, and it's a good starting place. There are a lot of issues in under the fee agreement that can be set out and will be important in defining different aspects of your relationship. Before we get into that, I see we mentioned that although you're representing your client in one area with respect to one case, and that's one of the first things you do, you kind of define the scope of the relationship by stating the particular case or circumstances or the date of the accident or whatever it applies to, and the names of the clients. You're also, you may be required at the outset to recognize that there are other claims that maybe you can't handle but would be available for this client. In Nichols v. Keller, the case that we've cited in the syllabus, you had a wife with a personal injury claim, and the attorney apparently neglected to tell her, or to tell her husband, that he also had a potential claim for loss of consortium. Okay, another example would be in, say, in a personal injury claim, you might recognize that there's also a possible workers' compensation case, or a third-party case in a workers' compensation case, a third-party claim against the, another company, maybe for, defective equipment that your client was using whilst on the job. So these are things that you need to know and you want to look for in respect to whatever field that you may be representing. Think, what else could be here? And were there children in the car? Do they have their own claims? Just go through it and take your time getting all the information in your first interview. Do you want to carry on?
Sure, thank you. There's the current requirement for what you have to disclose with respect to your legal malpractice in your written fee agreements in the rules of California Rules of Court. And there's a civil code section on if you're dealing with clients in foreign languages, and I don't know the statute off the top of my head, but in certain cases dealing with certain languages, you have to have the attorney-client fee agreement in that language if you're dealing with a client in a non-English setting. We recommend that you specify in your attorney-client fee agreement what your mode of communication is. This is where most of us communicate with other people by email. That's fine. I find it handy with my clientele to tell them that I am going to communicate email. I'm not going to send things US mail or fax, but some of my clients want it that way, so that's fine. It's part of client service. We'll take this up in about an hour, but specify your file retention policy. Awful lot of our clients call us and they've got 5, 10, 20, 30 years worth of client files. They don't know what to do with them. And so we are advising that the file retention policy be specified in the fee agreement so you can know when you can eliminate files. In contingency fee cases, probably the most common misunderstanding between attorney and client is whether your contingency fee is going to be calculated on the gross recovery or on the net recovery after cost. The statute requires that you not only state what it is, but explain how it works. And that will be something you should be real careful to do and do well. In some of your cases, you'll find that you wind up getting sanctions against the other side, typically in discovery battles, and sometimes that can be a moment of misunderstanding between attorney and client over whose money is that. Is that part of the recovery, subject to the contingency or subject to your hourly? If it's an hourly fee agreement, is that a credit on attorney fees? Just what is it? And so that's worthwhile addressing. If you're going to have a lien clause in your fee agreement, I will not attempt in this panel to explain to you the nuances of lien clauses, other than we have a couple of case citations here. There are a few clauses that people differ upon. I have my own opinions on them. I start off with, a lot of people write contracts and they insert in the contract that if there's a dispute, the prevailing party gets attorney fees. Sounds pretty good until you realize that if you handle your own fee dispute, you're not entitled to attorney fees, so you get case law on that. And you've just created a one-way clause that only the client can benefit from. And if you get sued for malpractice and you're insured, what do you care about where the attorney fees go? So it's again a one-way clause that benefits the client but not the attorney. Because California case law gives us the ability, shifting gears here, to withdraw from cases after giving clients proper notice and going through proper process, which is to say, just because I signed you up doesn't mean I got to stick with you to the end if the attorney-client relationship isn't working or if you just aggravate the hell out of me. And therefore, I don't put it with, so many attorneys put a withdrawal clause in their contract. It says, if you don't pay your bill, I can withdraw. Well, you can do that anyhow. And you may have just limited the ability to withdraw solely to failure to pay. Attorneys differ on whether they want disputes done in arbitration or in court if there's a subsequent dispute. If you're going to put an ARB clause into your contract, remember you cannot force the client to waive their right to what's colloquially called state bar fee arbitration, mandatory fee arbitration, in which the client has the right to take you into non-binding arbitration, not binding. It's mandatory, but it's not binding. It can become binding if you agree later. But you can't force the client to waive that, but you can require a client to agree to arbitrate after that, fee disputes or malpractice claims. And you make up your own mind on that and decide. The other thing I recommend is, if you have fee-sharing contracts, if you have conflict consents, if you have extraneous things, don't put them in the fee agreement. The reason I recommend you don't put them in the fee agreement is, first of all, it becomes unwieldy. Imagine your late client getting a 6-page contract when they walk in the door. But also, there are times when under the statute, written fee agreements are privileged. There are times you want to be able to prove the conflict consent or prove the third-party payor consent or prove those things where you can't get into the fee agreement. So you just want to keep them out of the fee agreement. Gary?
I actually have only one little piece of advice about the agreements, and that is that the state bar has a lot of advice about it. Plus, if you go to the state bar site, all of you probably know that already, but it's Cal Bar. Just Google that. It'll come up. And there you'll see, if you drill down a little bit, the area where there are examples of fee agreements, and they have, I believe, 3. So they cover they cover hourly, they cover contingent, and a kind of combo. So those are good examples, plus there is some advice on the bar site.
Are there other sort of best practices that you tend to put in your?
My fee agreement is, it lays out what the scope of in the first sentence really, the scope of my representation, so what they've come to me for, and I try to put it in pretty plain language. In fact, don't use scope of representation with your clients. So that's the very first paragraph. I set out very clearly that in my case, I generally require a deposit against fees, and that's the second paragraph. And it talks about the amount they need to give me before I will start work on the case, and then the amount that they need to keep that account, the amount they need to keep in that account so that we don't have any arguments about where the money is coming from. That usually works pretty well. I don't do that with long-term clients that I know and are just asking for advice, and it's not really litigation. But for any litigation, I require a deposit against fees of $8,000 up front before I'll put my name on a case. So that's one thing you really need to be clear about. And your fee, the amount of my fee, of course, my hourly rate is in that paragraph. The rest of the document has to do with the circumstances under which they can leave me at any time, and the circumstances, but put in general terms, nothing specific, when I can decide not to continue with them. And then the very last part of it is the statement about my malpractice insurance.
I want something, because this is, after all, a class for people who are to be newly solo. And I know this from my own experience. When you're the newly solo, a lot of these things sound really good until you're out there scraping for clients and willing to take chances that maybe a more veteran attorney like Carrie or Lindsay and I don't have to do. And that's okay. First thing I say is take your chances openly and don't fool yourself. And one of them has to do with somebody will come in and will say, gee whiz, I can't afford whatever your hourly rate is, will you discount it? And if you're going to discount it, hear this very carefully. Don't put the discounted rate in your fee agreement. Add a clause to your fee agreement that says, I will reduce your bill by X% or by $40 an hour if it's paid within X number of days of being billed. That way, you're giving them the discount. You're willing to give them the discount, but if you get in a fee dispute, the fee dispute's at retail and not at the wholesale rate. That's one thing that we advise, and it works. And we have a lot of law students who have struggles paying bills, and we do represent a number of law students at a lower rate, but that's how it's written up. You've got to pay that bill. And take credit cards. It's worth it.
There's a question.
Sorry, I just wanted to clarify. That was a really great tip, and I'm going to do that like in the 5-minute break we're going to have. You said that if there's a discount, where do you put it again?
In the fee agreement, it says my hourly rate is $450 an hour. I agree to reduce that to $400 an hour if your bill is paid within 30 days.
Right in that same spot.
Right there. Right there. So
Okay.
you're telling the client, I'm willing to give you a discount if you pay the bill on time,
All right.
but not if you don't. And if you want to charge interest, you got to recite that in your fee agreement.
So new solos, when they talk to me, often express a lot of anxiety about how to set that rate and what is that magic number, especially if they're new-ish lawyers. And I don't know if you have any advice or guidance on how do you land at that right number? And I'll open this to any of you, yeah.
Well, I do have some advice, and one of the first things I'd say is don't really go too low. People just, for some reason, they don't take that as a bargain.
Right.
They look at it as you not being really good enough to charge more. You need to factor in the fact that you're not as experienced, but try to get your experience some other way. You could do pro bono work or something, but, so one of the things that I suggest is that you talk to other attorneys in the field where you want to practice and ask them what rates are, find out what rates are, and then pick something that is gonna be good for you and not too low. Don't go out charging $125 an hour or something like that.
What I did in '92 when I first came back into private sector is I picked a range of hourly rates and just sort of randomly threw them out at people. Yeah, it was. But what I found was the factor you described. At what rate do I quote an hourly rate so that nobody takes me seriously? And at what rate are people not hiring me because for that amount of money they get somebody with real experience? And for whatever it's worth, you can see it on our website, because we're one of the few attorneys who actually puts our hourly rates right out there for everybody to look at. You know, mine is $450. We have a third-year associate who we now charge, what do we charge her out at? $275. When she was brand new, we charged her out at $225, but of course that's a supervised associate. I would say you gotta be above 200 to be taken seriously, and if you get up into the 400 and above, you're competing with me. and I have lots more experience, so.
No, but there are attorneys in big firms that are charging just humongous hourly rates. I've heard of $1,000 an hour.
My nephew,
So-
who's what, an 8th-year attorney,
Yeah,
is charged
yeah.
out at $6.25 an hour by his law firm.
So,
In
one of the-
bankruptcy.
So we talked about the initial, agreement, but, you have to send out bills, and,
Yeah.
and we've talked about how do you communicate with your client effectively, whether it's in the bill or some other statement. So Carrie, maybe if you can tell us, how do you handle that kind of ongoing communication in a way that makes sure the bills get paid on time and the clients are happy and well informed about their matters?
Well, I know that you'll both agree with me, we've talked about this. One of the most important things, and something you'll be judged about and is required by the Bar Association rules, is your bills need to be detailed. And when we say detailed, so that the client can look at the description and tell what you did. And more than just what you did in the broad sense, like email to client, discussed case. That's not sufficient. That doesn't tell enough. So you need to do something very specific. My bills happen to have, every task I do has a separate line, even if I'm not charging the client. Because to me, it's more work for me in the system that I use to eliminate those than to just have them show up. And plus, it shows the client everything I've done for them, even if I'm not charging them. And what I don't charge for are things like telephone calls to arrange meetings, emails to arrange meetings, something where I'm not doing any work. I'm not actually using my legal expertise. But they're very detailed. I do often, because my clients are businesses, include a separate statement that they can give to their bookkeeper or accountant, so that the confidentiality of what I've done, because I am so specific in the bill, that confidentiality in the company is protected, so that the bookkeeper or whoever's paying the bills doesn't see all of that detail. So that's generally what I do, 2 objects each month. And you do need to bill regularly, because if you don't, people don't pay. I had one colleague who waited until, he did wills and trusts, and he would wait until he finished the whole thing and then bill them. And that sometimes might be a whole 3 months. That's not a good practice.
Yeah, they call that sticker shock,
Yes,
right? When you wait
Right.
until you're all done and then you present them with a bill for, the 20 hours you put in.
One of the things that can help with that, though, is to give your client to communicate with your client regularly about what you're doing during that month. So if you're having telephone calls with them, then that's great, because you're doing that in person. But I happen to send every communication I have with third parties to my client first. I want them to see what I'm doing and what I'm going to send to an agency or opposing attorney. So they get to see the work as I'm going along, and copies of things attached to emails. That constant communication is what keeps people happy, so that they don't, even if the one monthly bill is quite large, if you've been communicating with them all month and it comes to them, they already know. They're not surprised. There just isn't any surprise.
We do, you have a question, go ahead.
I just want to ask, do you bill for the time that you're just sending copies to the client of all this?
No, No.
That never will come into your bill? What if it means compiling documents, and don't you have copy fees and things like that?
I don't charge my clients anything for copies unless I have to
Okay.
send it out, and then I charge them exactly what the copy service requires of me. I do the
Right.
same thing with, I don't add anything on to anything that I do with a third party.
Right.
I mean, like contract attorneys or process servers or anything like that. So I don't charge for faxes, or I might send any, but if I might get one. If it is obviously, if I get an email with an attachment that's long enough so I have to do work, or an long email with questions, 6 points, then I charge for that because I'm reading it and then responding to it. So I take that and I do charge for that, but I run a timer. My clients get billed by the minute, so it works fine for me.
I think the more we nickel and dime the clients, the more they treat us like mechanics. And we happen to follow a similar kind of pattern. Our fee agreement recites that we will charge back outside vendors to clients, and that we will only charge clients inside for large projects, defined essentially as something that takes more than an hour for my staff person to do. Other than that, my hourly rate should encompass my my cost, my overhead costs. Plus, I don't feel like a nitpicker where I'm taking time out every 3 minutes to record a phone call or whatever. And let me tell you, it's those things the clients will fight about, because that they understand. We do our work largely outside of the view of our clients. They don't know what we're doing. They're not in the office watching us, do legal research or engage in these things. So yeah, the steady communication is important. The steady billing is important. The billing, in our bills, we have the front piece that's similar to what you described, which is, last bill amount you paid, what's overdue, and what you owe me now. And then on the bottom of the first page, and by the way, it's sent out on our letterhead. It does not look like something I pressed a button from some computer service. It literally is sent on the letterhead. And the bottom is a status report. And basically is a synopsis of what is coming up in your case. Very often in the law, that status report is the same thing for 2 or 3 or 4 months, which is, I sent out interrogatories. I'm waiting for answers. I'm still waiting for answers. Trial date is 8 months from now. And the next thing we have to do is scheduled for 4 months from now. But that monthly report lets the client know you're still paying attention. Lindsay and I have a piece of personal litigation going, and we have beat our attorney over the head. It says, we don't seem to hear from you. Is anything happening? Have you died? Has our case died? Right, just, even have your secretary call. And that's what, we have a client who does big ticket plaintiff's work. He has staff people call his clients at least once a month, in addition to anything else that, sending copies of stuff out. Your bill should be descriptive, like Carrie said. A lot of people use, you know, these services out there, and client gets a bill that says TTOC, telephone call to opposing counsel. What the hell is that? And what does it tell the client? It's just like you're sort of a cipher out there, and I don't have time to write that I spoke to opposing counsel, nor to tell you what I spoke about. Right. Am I calling up opposing counsel to set a depot? Are we talking about the alumni function we went to last night? Or did I actually call up opposing counsel and say, you know, talk to opposing counsel and make settlement offer of, you know, $45,000? If you send it out every month, it keeps the clients informed, and it forces you to look at every one of your cases every month. And by the way, you don't have to pile them up and do them once a month. When I was fairly new and didn't have a lot of clients, I picked a different client each day and just sent the bill out. And when we got bigger, we, in our office, divide them up into 4 piles and send out 1/4 of our bills on the first Monday of each week. So I don't have that pressure on me that says, oh my God, I'm not generating revenue because I'm sitting here editing bills. And out they go. So yeah, send them out. The bill is your friend.
So you talked earlier in terms of the fee agreement about malpractice insurance and whether you should have it or whether you need to have it. So I guess there was the whether you need to have it, but then there's the whether you should have it, how much, advice on getting, finding carriers that will be friendly to new solos. So I don't know what advice you have, and then also other forms of insurance that a practitioner might need.
I can speak to
Great.
that.
Thank you.
We can both speak to that. We, in our experience over a long period of time now, we believe that it's very important to have malpractice insurance, regardless of whether you have to disclose it or not. It gives you the security of knowing that if you are sued civilly, you have a certain deductible that you'll pay, and you won't be responsible for any more than that. There are different kinds of policies. You can talk to the broker about what is covered, what is really essential, and what might be, maybe you want a policy that costs a little less, but your coverage declines as the case goes forward. The state bar usually recommends a carrier. Isn't it which one? The LA County Bar Association used to be the official insurance. They used to recommend an insurance company that they were affiliated with and that would offer good rates. You can just speak with, just talk to all of them and see what you feel comfortable with.
Let me interrupt because here's an interesting resource. There's a book out there on legal malpractice, well, 6 or 7 volumes by Ronald Mallon, M-A-L-L-E-N. He has a supplement to that set that discusses all the currently available legal malpractice actually in the country, but you can go down the index and see which is California. Most bar associations, like Lindsay said, the State Bar, the LA Bar, San Francisco, Trial Lawyers, SF Bar, have group policies that you can sign on to and generally get better rates. Go on.
What was the rest of the question?
So are there other kinds, as a business owner, are there other kinds of insurance
goodness.
that folks should be thinking about in addition to the malpractice?
Yeah, if you have an office that you're renting, or you're responsible for yourself and clients are coming there, then you need what is the equivalent of homeowners insurance. If you should have a fire or a flood or you have an accident in the office. And that's pretty reasonable. I think that a lot of insurance companies offer that. Another issue that I think many young attorneys don't realize is that you, depending on where you're working, where your office is located, you may be required to have a business license. And it may be the city, it may be the unincorporated portion of the county that collects the tax. You know, you don't know where, but you have to go and look for it, because if you practice for long enough, and I will say for more than a year, they come, you know, they'll come after you, and you know, they'll be looking to charge you back, you know, back payments and interest on it if you didn't have it. It's just another way that the city and counties collect revenue. So, you know, look into it and find out if, you know, you're required to have a business license.
You have staff, gotta carry workers' comp. Carry, I guess we call it, you know, functionally equivalent of homeowner's premises liability. It's good to pay the extra couple of dollars and check the box that covers essentially employees and messengers running errands for you in their own cars. I never thought of that until the first time I drove with my associate.
That's right.
Right. And yeah, the business license, and there was, anyhow, flitted out of my brain.
I have one thing. You should read any lease that you have with your landlord, because in my experience, the landlords all require you to have premises liability
Yes.
for the interior of your office. But they may not actually ask you for a copy of it. They don't necessarily say, give me a copy. So if you haven't read that carefully, you haven't read the release carefully, and even though we're attorneys and we tell our clients to read everything before they sign it, I'm not sure we always do that. So be sure and read your lease and make sure that if it does say you have to have that kind of insurance, that you get it. And again, it is really reasonable.
The bigger, more commercial landlords, the kind of people that own those 300-story buildings across the street, will not only have a clause that you carry insurance, they will ask that you obtain from your carrier a rider that is sent to them to show that you're covered, and a clause that gives them the right to buy insurance at your expense to cover you if you don't send them that rider.
Correct.
If I'm gonna, two other things. What kind of insurance? Talk to an insurance agent. What does this lease require? Your real estate, if you work with a real estate person, they will tell you. We've had a couple office leases now, and bless his soul, the real estate guy says, your lawyers, here are the areas I think you should look at. And he goes in yellow, highlights all the clauses that we better be careful to know about in our lease.
I just wanted to add on legal, I've worked in legal malpractice now for 12 years on the insurance company side, and a couple of things are, when you're a new attorney, it's a claims-made policy, so it's gonna be a lower price, and it goes up gradually. You could get it for under $2,000 a year starting out, and then each year it'll go up because you're covering it for an extra year. Another thing, so that's good news for new practices, but area of practice now, to be careful, because many policies now are excluding certain areas of practice, like real estate syndication, or the type of, like this, if you represent artists, entertainment is a broad field, and regardless of the kind of problem that artist had or how you represented him, may be excluded under the policy because they are an artist, whether they're famous or not, or a celebrity. So just to be careful about your language, the description of area of practice or exclusions. Many of the agents out there selling it aren't necessarily going to
Don't
point it
really
out.
know.
I talk to my broker every couple times a year to find out what areas of practice do you check off that doubles your policy. There are some areas, and if you're new, you might be tempted to check off everything, but you might find that you checked off something because you're interested in that area and just double or tripled your premium.
Like intellectual property, for
Right.
example.
Yeah,
It
Right.
sounds very sexy and you might not do very much of it, but your premium goes up with.
the other
kind of
thing is,
impact
once you
or-
carry insurance, remember two things. Claims made means you are covered for any claim that's made in the policy period, but you're protected because you're gonna have a second and third and fourth and fifth year. By informing your carrier, somebody who's used the magic word, I'm gonna sue you, or you committed malpractice, or something like that. The other one that can come up and bite you in the butt that's real sneaky is all the policies nowadays have clauses in them that say you have to report to your carrier when basically you reasonably have enough information to know that somebody can make a claim against you. And that seems to come up when you're renewing your policy. And that's the one where you're looking out there like this, going, oh my God. And the conventional wisdom is the more of these you tell your carrier, the higher your rates go. Let me tell you, it only takes one lawsuit and $50,000 or $100,000 worth of defense costs to let you know that these premiums are really well worth it. And let me tell you, every one of us in this room, except maybe the professor, will get sued for malpractice at least once in our careers. And most of the time, you won't see it coming, or you'll be, I'm thinking of two cases I worked on recently helping clients where somebody was carrying a $100,000 policy, new lawyer, doesn't handle big cases, just blew the statute on a $250,000 case. And so what should you carry? The answer is, what's the dollar value of your case, the cases on your case load? If you're handling, $50,000 cases, maybe a $100,000 policy will cover you. If you're handling $200,000 cases, then you probably underestimated it, double that, carry a 500 over $1 million policy. Or ask for the rates. My experience is the larger the policy, the rates aren't that significantly higher, and you don't even save much by taking a higher deductible. It used to be you could save a lot of money on your malpractice premium by simply agreeing to a higher deductible. Nowadays the premium, negligible on a $5,000 or $10,000 deductible. Yes.
So this sounds like coverage amounts for litigators, but do you have any opinion on coverage amounts for transactional attorneys?
What are you transacting? Are you selling downtown office buildings, or are you selling small
Good
businesses?
question. So if you're advising startup businesses and reviewing contracts and general compliance matters for certain industries.
Is this Ma and Pa Kettle who have 5,000 in their startup, or is this 5 guys from Google who put $100,000 each?
Probably more like the
Wow,
latter.
that's a $500,000 transaction with an expectation of profits. You better be up there. It's what you should be carrying should be governed in large part by the dollar value of the cases you're working. Are you probating $500,000 estates, or are you probating $5 million estates? You writing wills for people who are worth $20 million? Let me tell you, all the kids, stepkids, ex-spouses will be out suing everybody day before they die.
Yeah.
I
So-
also wanted to add the family members and friends, that's all I was doing is looking at malpractice cases, and oftentimes they come from where you least expect it. Maybe you're not even charging for some advice to a friend, and it goes awry, and they're gonna sue you,
Yeah.
So it's just that oftentimes those malpractice cases come from where, the attorney does not expect their brother to be suing them, or some aunt they just gave some little advice to, and not enough advice apparently, or something. And, relatives and friends are a place that it could come from, and pro bono stuff as well.
I want to move on a little, because we only have a little bit of time left for this segment and move off this very cheerful topic of
Medical malpractice.
yeah, but to perhaps a more optimistic topic in that, you know, assuming business is going well and you need to hire resources in your office, staff, contractors, there are sort of guidance, pitfall, you know, this is more kind of wearing your business owner hat a little bit, but what are some of the things people need to be paying attention to? You mentioned workers' comp insurance, sort of taxes, or the difference between dealing with independent contractors and employees, and why you might choose one path or the other, and
Well, since I'm an employment law
Yes.
attorney,
Yes.
We'll defer to you, Carrie.
the advice, and you should know that all of my clients are businesses. So I'm always advising people with businesses, such as you're going to be if you open your own practice. The first thing I say is that you should not be hiring directly any employees that, until you get to about 2 employees. Now, you may disagree with me, and that's fine, but there is this service called payrolling that you can get through any of the temporary agencies, where you are not the employer, you pay a premium for that employee. It is between 28 and 30% more than the hourly rate that you feel that person is worth, but that pays workers' comp, the employer taxes, because there are some taxes that only employers pay that aren't taken out of the employee's paycheck, that the employer pays directly. So you've got some expenses, and my last calculation was that what the payrolling service or temporary agency is getting is about 10% to 12%. That does not mean you hire someone that they bring to you. Payrolling is a different kind of thing. You find someone that you want to have work for you, and you go to the temporary agency and arrange for them to go through that temporary agency. So you can then have someone you want to have work for you, have all of the administrative tasks taken care of, withholding, all the things that come with a payroll. So I generally recommend not setting up your own workers' comp and payroll, et cetera, and hiring directly until you have a couple of employees.
Thank you for that advice. Thank you. I did not know that.
Yeah, it's something that they don't advertise much, because I think they don't really make a lot of money on it, the payroll and the temporary agencies. But it's been really good for my clients that are very small, that are starting out.
We have 4.8 employees, all of whom we hire directly, but we pay a service, ours happens to be paychecks, that does all the calculation of employee taxes, deductions, prepares all the returns, and every month I sign a check, and it's done right.
Yeah, that's the thing you do as you grow. That's actually what, that's another service, a payroll service that you would do, and don't try to do that yourself. Although if you had a bookkeeping service, they could do that. Some bookkeeping services offer payroll.
Can you explain a little bit what the difference is between that temporary service and then a payroll service like ADT?
Well, the temporary service actually is the employer. So you are leasing employees, basically, sort of. You are having people work in your business. If you do this payrolling that I talked about, you have that employee in your business, but they are not your employee. They are the employee of the temporary service. So you've heard of, Manpower, and there's one called Roberta's or something.
Robert Half.
Yeah, Robert Half. Those people actually put their employees in your place of business, but they're happy to take someone that you bring to them too, because that's just another body for them. They're increasing their load of employees. Now, that doesn't protect you completely, because of course if something happens at work and someone wants to sue you, they're gonna sue both. And there's a lot of precedent for the employer, the temporary agency, and the client, you, being considered co-employers. So that's not gonna completely eliminate liability, but it's certainly great for having all of that administrative stuff taken care of. The other thing is, we were gonna talk about contract attorneys. And we talked about this beforehand. We certainly agreed that contract attorneys are someone good to use, but you need to know them. So I've never hired someone to do work on my cases as an attorney, contract attorney. That wasn't someone whose work I knew. That wasn't someone that I knew relatively well. You can go to a service and get someone, but you're not gonna know what their capabilities are except what they've advertised and what the service has advertised. So I certainly recommend that you get to know attorneys, other attorneys in your practice area, and find out who might be looking for contract work if you have need for a contract attorney. And I'll tell you where I use contract attorneys. The really, really boring parts of discovery. I'm not going to do it myself. I like depositions, but it's the only thing about discovery that I'll do.
If you hire anybody as an employee, an associate, full or part-time, or as a contract attorney, you are responsible for their work. And if you're gonna put them out there, they represent you. So be careful who you hire, be careful who you put out there. There was a stretch in my practice where I did not have enough extra work for a second person. So I developed relationships with several attorneys and then got to know their work and gave them contract work. But by the way, one good way to test a contract attorney is invest about 5 hours of their time on a project you know the answer to. And just, I forget what it was, but at one time I had 10 versions of the same points and authorities. But at least I knew whether somebody was capable of finding the material or not.
So before we, well, I guess before we wrap up this hour, I want to see if there were other questions. Yes.
So you mentioned payroll. I know as you get bigger, there's other things to provide for employees like health insurance, life insurance, 401k. Are there resources that you look to as far as determining when you should acquire that stuff and what the options were? Or any suggestions?
Those are all benefits that are not mandated by any law, so really they're ones that you're probably gonna wanna talk to a broker about, because there isn't really a place where you have to insert that, because you don't have to insert it at all. You don't ever have to give any, except here in San Francisco. Sick leave, those kinds of things are not mandated by the state of California. Vacation isn't mandated. Now, some cities, such as San Francisco, have different rules, but you're gonna need to just talk to a broker about that and see when you get to the point. There are good benefits. I think of them as brokers. I don't know that they use that word, but I can give you, I can give people recommendations for that offline, where they have a whole package that you could look at and take whatever you want to offer to your employees.
I think you should also first talk to your employees and see what they already have. They may be covered for health benefits under their spouse's employment, so that may not mean as much to them as some other benefit. And sometimes you can work it out that you're giving a benefit on one hand instead of a raise, or you just try to find out what's the most important to the employees, and then what will also give you any advantage. So you're talking to your own accountant or tax advisor and your employees, and together when you all talk, you can find out what their true desires are and how you can best do it.
some of that would be governed by the federal law ERISA.
Right.
And so you would have to be careful that whoever you're consulting with knows about ERISA, because there are certain things that you couldn't offer just to one employee. You'd have to offer it to all of them. And so, you know, you couldn't offer it in lieu of a raise to one employee. It'd have to be offered to, but that's,
Right, certain retirements, medical plan, we're Kaiser members, and if we buy Kaiser through the office, then we have to offer it to all the employees. And what is it,
any pension,
Yeah,
all
any
the
pension.
pension ones are governed by ERISA, and
has to
those
cover-
health
yeah.
plans are governed by ERISA, so you have to look at that, you know, whoever you're dealing with needs to know the
Right.
federal law regarding.
There is an underlying thing here that I see among employers and employees. And when she said, talk to your employees, you know, about everything in the office. Keep your employees in the loop. I think it's funny, because I thought about my office, everybody's plugged into the computer, which means anybody who works in my office can know anything. No point in pretending it's secret. It's much more important to emphasize to the employees, first of all, the client confidentiality. But then if you put that discussion out there, what Lindsay and I found several years ago with one of our employees is an employee benefit of a car allowance was far more important to him because it was covered fully on his wife's medical insurance, and he was traveling a lot. And so that's where the employee benefit went. And the other thing is, part of it is when do you have to, of course, the legal requirement, but the other part of it is, I find, maybe it's just a personal prejudice, but that the employers who try and nickel and dime and keep their employees' salaries really, really low tend to have high turnover, bad employees, and are just basically ugly people. You know, especially if you're making a lot of money in the practice. You know, your first year out, you're struggling for every dime, that's one thing, but if you're making a fair amount of money, sprinkle some on the employees.
Yeah, and I would also say that in our world, we all know how to use computers. We can generate all of our own pleadings. We can do all this ourselves. That wasn't true, you know, back when I started practicing in the 70s. You know, we barely had a word processor, but, you know, there is still, well, some people still give dictation. A few dinosaurs amongst us, but you can't find stenographers anymore. But anyhow, if you don't have any way of affording a staff and you're just starting out, you're not alone. And you can do it all. And your client can come in one day and find you in your garage. Of course, you've carpeted your garage, and you're trying to collate papers, and you've got, you know, a row this long, and you're picking up, you know, page 20 of the exhibits when the client comes in and says, "You're my kind of lawyer. How can I help you?" Right? Because they respect that you're doing this all yourself when you have to. It's not, you know, you don't necessarily start out with anything. You know, most of us, you know, had nothing but student loans and no family support. And you go out on your own because it's a really hard time to get, you know, to get a job in a firm. And, you know, don't be ashamed of doing things yourself and learning to do them well. And then you'll be able to teach your first employee how to do it and explain to them what, you know, a proof of service is and how it has to be executed and filed. Things like that are what you'll learn. And I've found that the clients, you know, both of us have had this experience, that the clients never thought any less of us. They thought that, wow, we were doing it all. And, you know, taking care of a family and everything else we were doing at the same time. So, don't feel like you know, won't be impressive enough if you can't afford employees.
Thank you. I want to wrap up this portion so we can begin the ethics conversation. And I know we're kind of short on a break, and so I'm going to encourage folks, maybe if you just need to, it's the same lineup of speakers, so we don't need a lot of time to turn things around. I know folks need to sign in their paperwork, and I'm wondering, Carla, is there a way to even, in the interest of keeping things rolling forward, to bring the sign-in sheets to, because there's no new transition of handouts?
I'll just pass them around.
Is that, will that work? And then we can just kind of keep rolling. If folks need a break, go take a break, but we'll just keep moving forward.
We might trade seats just to confuse you or let you know you're in the panel.
So I don't even need to introduce the speakers because you know who they are, but we do want to give you your full hour of ethics credit. Let me grab my notes as we transition into our ethics conversation. It'll take about a 30-second transition. Here we go. Okay, ethics and professional responsibility.
I think I'll take
You want to take a little break?
1 minute.
Okay.
That's great.
Thank you.
Here, we'll take a 1-minute break if folks need to